at the end of this presentation, this is not so clear for what regards cross-border placement, where there is a point which is seems to run counter this statement. And a criticism which I think we should take into consideration is the fact that unfortunately the EU didn't take a clear statement on unaccompanied minors, which are mentioned, and under recital 25 there is a good connection again with the 1996 Hague Convention for what concern the jurisdiction in case of refugees children or children not having habitual residence. But as we know, under the 1996 Convention, there have been problems in extending the scope of application of that convention expressly to unaccompanied minors. So perhaps the EU could have been a little bit more open to provide a clear statement on this and to extend expressly the provision to unaccompanied minors. If we move to jurisdiction, which is a topic I'm not going through very in detail because my colleague Giacomo will consider it, my purpose is just to show you that the general structure didn't change very much. We have this general rule on the habitual residence, and we have these rules which gives more flexibility as the proposal was meant to achieve. So we have this choice of court rule, which is very important because, of course, it's much more detailed and it's open to coordination also with other instruments. And we have also the transfer of jurisdiction under now Article 12, which is becoming much more used in practice. We have a lot of cases before the Court of Justice, and which is now becoming really bilateral as it happens under the 1996 Hague Convention, so where the transfer of jurisdiction may also be required by another forum. We have also this new rule on incidental questions, which helps practitioner to solve problems, practical problems which arise mainly, as pointed out in the recital, in succession cases. So the whole regime on jurisdiction has surely made a step forward in this regard. Not to talk about the provisional measures on which a specific seminar will be held in a few days. It's very difficult to really understand the key, what is the best interest of the child in concreto in any case. So we have some guidelines from the Court of Justice in the case of Saponaro, for example, where the definition seems to be in negative terms. It's fine so far that it does not prejudice the interests of the child. A choice, in that case, is a choice of court, and then the proof that that court is connected with the child. And in another case where the topic was the transfer of jurisdiction, it was mentioned a specific added value, meaning that this added value should concern the rules of procedure of the member states, not substantive law. Otherwise, the principle of mutual trust could be harmed in this regard. So the real perhaps challenge will be to understand whether it's going to be possible to provide a sort of as much as possible uniform definition of what the best interest of the child is in any case. If we move to the recognition and execution side of the regulation, again, the balance is new because the idea is to, of course, improve recognition and execution, so meaning that this in general is in line with the principle of the best interest of the child, but also take into account specific circumstances in specific case which might stop this mechanism of free movement of decision of order within the EU legal space. So we have the abolition of the exequatur for all the decision already mentioned by my colleagues, but we have also some weakening mechanism of the so-called privilege decision, which have been also defined as the nuclear bomb of the judicial space, of the European judicial space, and which now might be stopped, might not be recognized in case there is some contrast with the later decisions rendered. So there is a stop on the functioning of these very powerful decisions now. And beside this, also those privileged decisions, but all the decisions in parental responsibility matter face the limit of Article 56, and it's possible, therefore, at the later stage of enforcement to suspend or even refuse enforcement when there are some grave risks of physical or also psychological harm for the child, which might be temporary, and then we have a suspension, but could become also of lasting nature, and then refusal might be even justified. So we have this possibility to take into consideration the reality, a sort of reality check, which can be done at the very latest stage of this cooperation. For what concerns the involvement of the child, of course, we are talking about progress in the promotion and protection of the interests of the child. And the involvement is stronger, clearly, because we have a specific provision establishing the right of the child to express his or her own views, which ends up to be sort of a clear and genuine and effective opportunity to express his own view. And we have, again, the same right for return proceedings. Nothing similar exists in the other and the parallel conventions in the Hague under the Hague system. So it is a clear position adopted by the Brussels IIter regulation. Similarly, for what concerns cooperation, again, a topic which will be considered more in detail in further sessions, we have important rules establishing exchange of information, which, on my point of view, are very relevant because gives the whole picture of the concerning the child, the situation of the child, not only on the child himself, but also on the parents, on the siblings. So it's possible really to have this whole picture on the child situation, which is important because it might be used in the child abduction proceeding when we come to the merit, and so we can really comply in some way with the requests from the Court of Human Rights in the Nurlinger case, but also in other cases, such as Carpaneto, for example. So it is possible, thanks also to this cooperation and to what is said by the articles on child abduction, to really find out what is the best solution for the child after the abduction. But also this picture of the child can be provided also in cross-border placement proceedings. In this regard, let me just make a small remark on the new regime on cross-border placement. To go back to the scope of application, the cross-border placement now is more clear. It's clear that it's not possible to adopt it in case of placement in view of adoption. It's also clear that we do not have to go through this procedure when placement is with parents or even close relatives. It's clear that it can apply to educational placement, but there is this exclusion which sounds less clear. It's not possible to place a child abroad if this placement is made because of an act made by the child, if committed by an adult, could be punishable under national criminal law, regardless of the fact that the child is convicted or not. This is, of course, not in the article, in the regime under Article 82, it's in Recital 11, but it sounds a little bit formalistic, given the fact that frequently placement is also used, in particular by some states, in order really to move the child away from a specific context which was not good for his growing or her growing, and so perhaps this. I don't really understand the purpose of such provision. On the other hand, the new regime is very much developed because it takes into account, as I was saying, the picture of the child, because the requesting state shall provide a report on the child, which recital 83 describes quite in detail, gives a lot of information on on the content of this report, which should give to the member state of destination the possibility to really evaluate the measure of protection and also its effective use in the state of destination. And the most important of everything, more important than everything, is also the fact that is required now the previous consent of the member states where the placement is going to be done. So it's not anymore possible to place the child abroad without the consent of the authority of the state of destination. And this consent shall be done quite quickly within the term of 3 months. I don't know if this is going to be easy to do because as we have experienced procedural rules, national procedural rules concerning this administrative procedure are not uniform even at national level. So it's going to be difficult to respect this deadline, but it's very important that the previous consent is now a binding requirement, as well as the necessity of a new consent in case the placement is going to last longer than expected from at the first sight. So, as I was saying, my feeling is that the mission has been accomplished, and the Brussels IIter regulation is a complicated, sophisticated regulation, but it can work in practice better than its previous version. And so I thank you for your attention, and I leave the floor to my colleague, Giacomo. Thank you very much.